to the latest response that's coming from the chairperson of the Adani Group, who's responded to the Supreme Court order, says Satyamev Jayate. We have Swati joining us with that detailed response. Yes, Swati.
Absolutely. Kritzwin, like you and Harish highlighted, this is a clean chit by the top court to the Adani Group. The court has made it absolutely clear that there is no ground to transfer the probe, so it has refused the demand of fresh investigation. This is the first response coming in from Gautam Adani. Let me quickly read out the tweet that he has put out. The Honorable Supreme Court's judgment shows that truth has prevailed. Satyamev Jayate. I am grateful to those who stood by us. A humble contribution to India's growth story will continue. Jai Hind. So he said truth has prevailed and the Supreme Court's judgment clearly indicates that. Back to you.
Many thanks for that, Swati. Let me quickly go across to Bhavtosh as well, with the Supreme Court saying there's no ground here to transfer the probe in the case, and it can be raised only if there's a willful or deliberate violations of rule. Speaks for itself, Bhavtosh, that the Supreme Court sees no violation of rules in this particular case. A big clean chit really to the Adani Group. The SEBI has to now conclude its probe in the next 3 months.
Yes, Christine. In fact, as soon as the Hindenburg report came out, they were, in fact, it was the report was quoted by several media organizations, particularly foreign press, and that was in fact used by the opposition leaders not only to target the business empire of Adani, but also in a way connect Adani with the BJP, claiming that this is a perfect example of crony capitalism. In fact, in the judgment that has been delivered by the Chief Justice's bench, it particularly mentions a very important point that I will like to highlight, is that the newspaper reports cannot be concluded as a credible evidence. Unverified press reports cannot have precedence over a probe by a statutory authority, in this case SEBI, which is a regulatory body. And it has further said that powers of SC to enter regulatory domain of SEBI in framing of delegated legislation is very limited. It further goes on to say that the reliance on OCCPR, which is a group of journalists, report is rejected, and reliance on a third-party organization report without any verification cannot be relied upon as a proof. What had happened for past 8 to 10 months is that there were several reports that were published and also put out on Twitter and other social media platforms, claiming that because the Hindenburg report is out in open, and because there are reports which are coming on in foreign press, which was repeatedly quoted by several opposition leaders, they believe that this is a gospel truth, and that is the reason why BJP is at fault, and also Adani should be probed by an independent SIT. Now, the Supreme Court order, which has been delivered by the Chief Justice bench, has said that just because the report is coming out in various press reports and also in international press, that cannot be treated as a gospel truth, and they will continue to wait for the SEBI's final report to come out, which will in fact will come out in next 3 months.
Okay, many thanks for that, Bhavtosh. Stay on with us. Naturally, many are also viewing this court order as a big setback to the Congress, because they are the ones who almost made it their single point agenda to target the Modi government on what they claim are alleged malpractices by the Adani Group. In fact, let's quickly play out some of these statements made by Rahul Gandhi on the floor of the House in the Parliament against the Adani Group, and then we discuss how all of these arguments have been countered by the top court today.
Adani ji ko 6 airports diye gaye. After that, India's most strategic, profitable airport, Mumbai Airport, was taken away by GVK, hijacked by using the agencies. रूल था कि अगर कोई एयरपोर्ट बिजनेस में नहीं था तो वो इन एयरपोर्ट्स को ले नहीं सकता था. इस रूल को हिंदुस्तान की सरकार ने बदला. ये भी सवाल पूछा, ये भी पूछा कि भैया एक बात बताइए, राहुल जी बताइए हमें कि अदानी जी का जो नेटवर्थ है वो 3 साल के अंदर, नहीं सॉरी 2014 से लेकर 2022 तक ये $8 बिलियन से $140 बिलियन कैसे हो गया?
कैसे हुआ?
एल्बिट कंपनी के साथ हिंदुस्तान में अदानी जी ड्रोन्स बनाते हैं. ड्रोन्स को हिंदुस्तान की एयरफोर्स, आर्मी, नेवी के लिए रिफिट करते हैं. स्मॉल आर्म्स का बिजनेस मिल जाता है, इजरायली जो ड्रोन्स हैं उसका बिजनेस मिल जाता है। मतलब जो हिंदुस्तान और इजरायल का डिफेंस का रिश्ता है वो पूरा पूरा अदानी जी के हाथ में चला जाता है, खत्म कहानी। यात्रा में लोगों ने मुझसे पूछा, राहुल जी ये जो LIC कंपनी है इसका पैसा अदानी जी की मदद करने के लिए क्यों डाला जा रहा है? हजारों करोड़ रुपए हिंदुस्तान के पब्लिक सेक्टर बैंक्स अदानी जी को मिलता है।
Let me quickly go across to Akanksha as well. Akanksha, you know, to all of these charges leveled by several in the opposition, including Rahul Gandhi, Gautam Adani comes out to say truth has prevailed, Satyamev Jayate. But this really is, in a sense, an answer to those in the opposition who kept talking about the Adani case. In fact, not just, in the winter session of the parliament, but also not just in the monsoon session of the parliament, I beg your pardon, but also on the sidelines of the winter session of the parliament.
Well, absolutely. Remember, Hindenburg came out with this report last year in January, and after that, we saw clamour in Parliament as well as on streets, and Congress coming out to link it with the Bharatiya Janata Party. In fact, Rahul Gandhi last year also said that if they are voted to power, they will initiate probe against the Adani company, and they also linked it to the Bharatiya Janata Party. But today, the court very clearly stated that the petitions are based on incomplete investigations. Also, newspaper reports cannot be relied on by the petitioners, is what the Supreme Court said today. And right after the judgment, we saw the tweet coming from Gautam Adani, wherein he said that truth will prevail and Satyamev Jayate, Jai Hind. So definitely remains to be seen how Congress party now responds to this, because this is definitely a big setback for the petitioners and a huge win for the Adani company.
Okay, many thanks for that, Akanksha. Let me now go across to Mr. Sumit Agrawal, who's been waiting patiently with us on the broadcast. Mr. Agrawal, the court has rejected the arguments of petitioners regarding conflict of interest on part of the members of the expert committee. It's refused to order a fresh probe, but it has added that the government of India and SEBI shall take into consideration recommendations of the expert committee to strengthen regulatory framework to protect the interest of Indian investors. And that's where the sum and summary of this entire issue also lies, to protect the interest of Indian investors. That's something we're still aiming for as a country, given this case.
No, absolutely. The way I see it is that this Supreme Court judgment is actually a landmark judgment. This is like giving Adani Group a dip in Ganga. And if I can say that it is not redemption only for Adani Group, it is rather redemption for robustness or the maturity of the regulator SEBI. And let's see why Supreme Court said this. Supreme Court had said that there is no ground whatsoever to transfer the investigation from SEBI to SIT or CBI. The petitioners were asking the transfer of the case from SEBI on the ground that SEBI has been lax in terms of formulating the regulations or applying the current regulations in the strict manner. Supreme Court found no ground whatsoever. In fact, Supreme Court upheld that the amendments made to these regulations, like FPI regulations and the listing regulations, do not suffer from any infirmities. Secondly, Supreme Court also said that if any third-party information is to be relied upon, that has to be relied upon only when that report or a publication comes up with some kind of a verification or a substantiation. Without a verification, no such publication can be relied upon as a proof, especially not as a conclusion against any person to accuse. So this is a case where rather an accuser becomes the accused, because Supreme Court even went ahead and said that if there is any violation to be found by the Hindenburg report or the short sellers, SEBI in its investigation must recommend an action and take action in accordance with law. So the way I see it is that it is a redemption for the tenacity of the capital market regulator.
Okay, Mr. Agarwal, also like my colleague Bhavtosh was pointing out, the court has also issued a word of caution against lawyers filing public interest litigations without adequate research and by relying on unverified reports. And that's sensational in this case, especially given how this issue was time and again raised by many in the opposition. At a point where crucial discussions could have taken place, for example, in the parliament.
No, absolutely. In fact, we must look at it from another angle also. SEBI is there not for public interest. SEBI is there for the investor's interest. Is there a difference between a public and an investor? And we need to consider in the context that today, after the Supreme Court question, there will be a lot of questions on this entire process, because today restitution is perhaps due to not only those investors who lost money due to certain short selling, but also it is due to all of those people because Adani Group had to cancel its FPO and return almost 20,000 crores back to the investors in February. Now, this entire process on the basis of some unsubstantiated allegations were to be taken further, then this really calls for an institutional question. And in this context, Supreme Court said that the expert committee report, which asks for a robust enforcement policy, must be looked at by SEBI as well as the government of India while bringing amendments in the due course.
Okay, many thanks for that, Mr. Agarwal. That's the big takeaway, the biggest takeaway so far in this case, with the Supreme Court making it very clear that there is no room currently, at this junction in the investigations to have an SIT or a CBI probe take over in this particular case. SEBI has to continue with its probe. A 3-month deadline has also been set by the Supreme Court.